Well, go ahead. Welcome and thank you all for joining us for this Consumer 101 training. I'm Stacy Francis. I'm the Deputy Director at Legal Services Vermont, and joining me today is Rachel Jones. She's our Consumer Staff Attorney at Legal Services Vermont. And for the next hour, we're going to do a very basic Consumer 101 training, primarily focused on debt collection and debt collection procedures and processes. I'm going to give a quick overview and then Rachel's going to go into the process in a lot more detail. If you have questions, please feel free to put them in the chat and we'll try to watch and monitor that, and hopefully there'll be some time at the end for additional questions. All right, so that's sort of just a quick overview of the topics, and then we'll start with a few sort of common terms. So in debt collection, there are just a few key terms. So the first one is just the debtor. That's generally the person who's your client who owes money to someone. Generally, there's an original creditor. That's going to be your credit card company, your bank, your student loan provider. And then there's the third-party debt collector. And third-party debt collectors generally fall into two categories. One is they're hired by the original creditor to just assist in collecting the debt, or they've purchased the debt from the original creditor and now they hold sort of the title to the debt and they're collecting on their own. In Vermont, the statute of limitations to recover on a consumer debt is 6 years. And usually that's 6 years from the default or when the client stopped paying. And then we'll use the term judgment proof. And so judgment proof refers to either income or an asset or a source of income that's protected under Vermont's exemption statutes. And so that means that at that period of time, the debtor can generally not the debtor, the creditor can generally not collect that type of income or asset because it is protected. And again, that can change in the future. So it generally relates to that period of time. So there are a couple of sort of statutes, acts that relate to debt collection. The general one is the Federal Fair Debt Collection Practices Act, which is often referred to as the FDCPA. This is the act that regulates third-party creditors. So it states what they can and cannot do when collecting a debt. Then there's the Vermont Consumer Protection Act, which used to be referred to as the Consumer Fraud Act, and you'll still sometimes see that referred to as the CF. And then there's the Vermont Consumer Protection Rules. Those come out from the Attorney General's office. So to sort of start at the very beginning, what happens in the process? So you're working with a client who's fallen behind, maybe a couple of months on a credit card. Usually the first thing that happens is that creditor is going to report those late payments and defaults to someone's credit report. And so that will show up as a notation on the credit report. The general rule is it can stay on the credit report for up to 7 years from that date of delinquency. If someone ends up filing bankruptcy, that will change how it shows up, and usually that debt gets zeroed out, but the bankruptcy can show up as a notation on a credit report for up to 10 years. Sometimes there are inaccuracies on credit reports. If that happens, you can dispute it with each of the 3 credit reporting agencies, and they'll investigate and decide whether or not to remove it. Sometimes a consequence is that landlords use tenant screening agencies, and sometimes that can involve pulling credit reports. So if you have negative credit, that can affect your ability to get housing in certain circumstances. The 3 credit reporting agencies are Equifax, Experian, and TransUnion, and everyone is entitled to get a free copy of their credit report from each of the agencies every 12 months. So sometimes it's helpful for clients to get that and see, and you can space them out over the course of the year. So you can, get one at the beginning of the year and then another midway, and then it sort of just keeps cycling that every 12 months. To get that free credit report, you can go to annualcreditreport.com. It is a free site. They will offer you extra things that you have to pay for, but just to get your credit report should always be free if you go to that site. So one of the other things that will happen when you fall behind on a debt is you're going to start to be contacted by the creditor who's trying to collect. This usually happens through multiple phone calls, sometimes harassing phone calls, texts, mail, letters. Even if the statute of limitations expired, they often still will continue to try to collect. Oftentimes, your original creditor will sell it to a third-party debt collection agency, And sometimes that debt collection agency will then sell it to even another debt collection agency. And often that will restart that cycle of calls. So now you start getting calls from whatever new company is trying to collect. At some point, often the original creditor or the third party debt collector will decide to sue you, and that can either be in small claims or superior court, depending on which venue they prefer and the amount that they're suing you for. And we'll go into that a little bit later. And then finally, if that creditor gets through the court process and ends up with a judgment, it can have consequences. And so that judgment can result in wages being garnished if your client makes more than the exempt amount. That judgment can be filed as a lien in the land records on someone's home. And later on, we'll talk about whether or not you can do anything with that lien, but that can keep someone from being able to sell in the future, even if they're exempt. Sometimes you can freeze a bank account. And then also judgments are generally good for 8 years and can be extended if you renew. And so the creditor can continue to watch down the line to see, does someone's income drastically increase, or do they come into an inheritance or something like lottery winnings? And then at that point, the creditor can still try to collect. So there's a couple of kinds of categories where the government sort of has super collection powers, and these usually relate to federal debts. So these are things like your Social Security overpayments, you owe money to the IRS, you owe on a federal student loan. And in those cases, the government can collect from you without having to go to court. And what that often looks like is suddenly they'll start taking a percentage of your Social Security monthly check, or they'll intercept a tax refund to pay that debt, or in some cases, they can get an administrative wage garnishment. And you usually have the right to request a hearing, or sometimes you have the right to sort of show that that's going to be a really strong financial hardship for you and get the amount that they're taking reduced. But the government can do that without ever going through the court process. So now we'll switch and just talk about repossession briefly. So auto loans are considered secure transactions under the UCC. And so in practice, this means that if you fall behind on your car payment, whoever sort of holds that loan can come and take possession of your vehicle without having to go to court first. The one caveat with that is that they can't breach the peace in the process of taking the vehicle. So if you're keeping your car in a locked garage, they can't come and break into your garage and take it. But if your car is just parked on the street, they can just come and repossess it if you are behind on that loan without going to court and without really telling you that they're going to do it. So often, if we have clients who think that there's a chance the vehicle is going to be repossessed, we'll advise them to not keep anything valuable in the vehicle, because what often happens is pretty quickly after the vehicle's been repossessed, they'll move it to either another location or out of state to be auctioned. And at that point, you have the right to get your personal possessions back, but they don't have to proactively like send them to you. You may be responsible for the shipping costs, or you may have to go there to get it. And that can be a hardship for clients if it's a long distance. Once they have repossessed the vehicle under state law, they have to give you two notices. One is the notice of the sale. So generally that's a notice saying we're going to auction your vehicle and here is the time and how we're going to do it. And then once they auction off your vehicle, they have to give you a notice of what they sold it for and whether or not there's a deficiency or surplus. And so often what happens is they've taken a vehicle, you may still owe, let's say $10,000 on it, they sell it for five, and so you still owe $5,000 in a deficiency on that loan. At that point, they can decide whether or not they're going to sue you for that deficiency, again, in small claims or superior court following that debt collection process. And they have 4 years from the time of that sale to sue you for that deficiency. And then sort of finally, there's identity theft and scams. So oftentimes we'll have clients who will say there's something showing up on my credit report that's not mine, or I'm getting debt collection letters about a debt that's not mine. In those cases, we recommend clients do several things. First, when they notice that transaction on their credit card or they see that a card's been opened, they immediately notify whatever card, whatever credit card company it is, and dispute it. Oftentimes, those companies are going to want you to file a police report, so we advise clients to do that. That can be a little tricky when it's a scenario. It often tends to be like a grandparent and a grandchild that's used the card without authorization, but usually to get that taken off of you being liable for it, they are going to want to see a police report. And then you also can report it to those 3 credit reporting agencies and dispute it there. And then you can also, for the future, lock your credit reports so that no new cards can be opened without you having to proactively go in and authorize it and sort of unlock it for that period of time. The best overall tool I've seen for identity theft is the FTC's website. They have a really good sort of guide that walks you through all the steps you should take if you think you've been the victim of identity theft. And then also, if you think you've been the victim of a scam, you should report that to the police. Sometimes they'll have you report it to the FBI and also the Vermont Attorney General's Consumer Assistance Program. They try to track scams that are happening in Vermont to see if they can find enough of a pattern to potentially take action. And so that's my general overview. I'm going to pass it off to Rachel to go into a little more detail in the process.
Hello. So there are a number of ways debt collectors can try to collect a debt before even filing a lawsuit. So I'm just going to go over again a very general overview of this process, applying to different types of debts, such as credit card debts, different types of loans, medical debts, etc. So just as Stacy had mentioned, there are original creditors who collect the debts that they have had before. Then there are debt buyers or debt collectors that have bought debts from the original creditors, and we are going to go over both. Original creditors can call, text, mail, or email debtors about the debt, and while debtors can ask them to stop calling, debtors can't force them to stop contact. They may have hired a debt collector or assigned a debt to a debt collection agency that will call or try to collect on their behalf, or they completely sell the debt to a debt buyer outright. Neither original creditors nor debt collectors can harass a debtor. They can't make threats that are untrue. They can't make misrepresentations. And debtors do have more rights under the Fair Debt Collection Practices Act, which applies to debt collectors. And just as I previously mentioned, debt collectors and creditors cannot make empty threats or harass, calling at odd hours of the day or night, or using profanity. These are all different rights that a debtor might have against a creditor or a debt collector. And so a debtor has a few options if they are encountering violations of the Fair Debt Collection Practices Act or the Vermont Consumer Fraud rules. They can send letters, a letter asking the collector or creditor to stop. In this case, under the Fair Debt Collection Practices Act, a debtor can ask a debt collector to stop calling, and the debt collector is supposed to stop calling once they receive that letter. The Fair Debt Collection Practices Act does not apply to original creditors, but again, debtors can still send letters asking the original creditor to stop calling and request that.
Can I just add, Rachel? So under the FDCPA, if you send your creditor a letter only a third party creditor, but if you send your third party creditor a letter saying, I do not want you to call me anymore, stop calling me, and then they continue to call, that is a violation of the Fair Debt Collection Practices Act. And if it's sort of egregious enough, you can proactively go after creditors if they are violating that FDCPA. Again, it won't work if it's the original credit card company that's contacting you. In that case, the only real option is if you can build a pattern of harassment, you can try to go under the Vermont Consumer Protection Rules.
Mm-hmm. Which does cover, different methods of harassment, like calling at odd hours of the day or, contacting a person with the purpose of just harassing or causing difficulties. Yep, and that was just what we went over, the do not call letter that somebody can send to a third party collector asking them to stop. And okay, so I'm going to go over debt collection lawsuits. Again, a very brief overview. They aren't always filed for every debt collection or debt collector or creditor, but this is one way that a debt collector or a creditor could try to enforce collection or try to get somebody to pay. Okay, so the Superior Court process just follows the Vermont Rules of Civil Procedure as other civil cases would. There would be 21 days to answer the complaint. Once that is served, Rule 4, the Vermont Rules of Civil Procedure also applies. So for example, the plaintiff must follow all service rules, must provide a blank answer form, a blank notice of appearance form, and just comply with Rule 4. The defendant must answer each claim or each paragraph in the complaint, and they must file the answer with the court and then provide a copy to the other party just as they would in any other civil case.
And I'm just going to mention, because I think we have some time, that it's really important for the clients to answer. A lot of these cases that sort of end up with judgments against clients are because they haven't answered and they end up with default judgments. And so generally, it would be okay for a client to completely answer it and just sort of say, I don't know to all the answers. I don't know if I owe this debt. I don't know if the amount is correct. I don't know when my last payment was, to at least have a chance to get into that hearing and dispute it, or at least have the creditor then show, yes, in fact, I can prove that this is your debt, or yes, in fact, I can prove that we, the third party debt collector, purchased this debt properly, and show how they came to the number they came to. So I just wanted to
Yes.
add that.
And if a defendant answers that they don't have enough knowledge to support their answer, or they just don't know, that is counted as a denial would be counted. So so again, a lot of defendants, don't recall certain claims. Maybe they don't know certain dates or certain amounts that are claimed. So again, saying I don't know in that respect would be, a valid answer. So there are some defenses that could be used. Vermont's Rules of Civil Procedure 9.1 lays out requirements for a debt collection complaint for credit card debt specifically. There are certain pleading requirements that have to be on the complaint, and if they're not, the defendant could use the mission as a defense. So, for example, if it's a third party debt collector, they have to show the chain of ownership, or they have to plead the chain of ownership in their complaint. They have to include the last four digits of the account number to show that they have proof of this debt. They have to allege the last payment date, the date of default, and the basis of default, the dates and parties. So when the contract was allegedly made, they must include that in the complaint as well. Oftentimes, they will also attach billing statements or statements showing the chain of ownership to the complaint. But the rules just say that they have to include this information at some point in the complaint. And then also in small claims court, Rule 3H mirrors the 9.1. So again, it's a similar process. So if a debt collector or a creditor sues in small claims court for a credit card debt, they have to follow the same requirements and include all these pieces of information in their complaint as well. And there are some other defenses that could be used just to show that somebody doesn't owe a debt. For example, if there's identity theft or fraud and somebody else who is not authorized put charges on a credit card, that might be a defense. The debt is not a debtor's. There could be mistakes made. Maybe there's the wrong name or somebody doesn't recognize the debt. Maybe the debt was discharged in bankruptcy. And then there could be also procedural defenses, such as failure to serve within 60 days of filing. Maybe there was not a blank answer form or notice of appearance form. There are a number of defenses that somebody could use, showing that that service was incorrect. So again, these are all just possibilities, but generally the defense, whether it would either be procedural or it'd be a defense showing that somebody does not owe a certain debt. And then for most cases, the complaint or the lawsuit must be brought on within 6 years of default. So a debt collector or creditor cannot sue on a very old debt. They can still, as previously mentioned, they can still call or try to collect in other ways, but they can't actually go to court for a debt that has been defaulted on, before that 6-year period. Now, there is one caveat. If somebody makes a single payment on the debt, that clock could start again. And if they make a payment and they default again, the debt collector or creditor could sue, as long as that default date is within that 6-year period. And in some cases, the plaintiff might issue discovery requests. For example, the defendant might receive requests to admit, and if they fail to respond to these requests, that could be taken as an admission. So it's very important for the defendant to respond to all discovery requests. The defendant might also receive interrogatories or requests to produce. Again, asking questions about what information they might have or the basis of their denial or a variety of information that might be asked. If the requests are irrelevant or overly burdensome, the defendant can object to the discovery request, but they do have to answer. So, it's important that these requests are not ignored. Yep, and these are just rules that cover, discovery requests, just as other civil cases would. Yep, and oftentimes what happens is people are served discovery requests in a single packet. So somebody might get a packet of information that has interrogatories, requests to produce, and requests to admit all in one. Again, they need to respond to all of those within 30 days. If it's not possible, they can always ask for an extension. But again, it's very important that the defendant responds to all requests.
I'll also add that the defendant can also serve discovery. So if you have a client who's not sure who this third party debt collection agency is or really thinks that the amount they're being sued for is wrong, they can serve discovery on the creditor to try to get information to show, how did you purchase this debt? Show me the chain of title. Show me how you got to this number or how you calculated interest, to just have that information to also help bolster up their defense or figure out, is this actually something I may owe or not owe?
Right. So it's the same process. It would be 30 days that the plaintiff would have to respond to those requests. And again, they can object to requests that they think are irrelevant or overly burdensome, but they would have to respond to that as well. Okay, so at the end of the day, the plaintiff is seeking a judgment, and there are a number of things that this can result in. For example, so if the plaintiff wins a judgment, whether that's a default judgment with the defendant not answering, or if that's after a merits hearing, there is typically a 12% interest rate unless that interest is waived and very clearly stated in writing that it would be waived. If a person has income that is not covered by Vermont's exemption laws, which I will be getting into pretty soon, the the plaintiff can seek wage garnishment. They can file a motion for trustee process, which might allow them to garnish somebody's wages. They could put a lien on real property as long as that property is not exempt under Vermont's homestead exemption law as well.
Well, and just to clarify there,
Mhm.
Rachel, they can put a lien on either way. They just can't foreclose on the lien if
Right.
it's
Yeah.
within the homestead exemption. So they can
Yes.
put a
Thank you.
lien on, yeah, sure. And they can hope that even if it's not exempt now, down the road at some point, maybe you'll build up enough equity in the property that they can
Right.
collect. And so it does sort of cloud the title a bit moving forward.
Right. So the lien would just sit, but it's yeah, exactly. They can't foreclose until the amount of equity in the home is above the threshold. And then for bank accounts, same thing. They can attach bank accounts or freeze bank accounts if the amount of money is not exempt. Um, the judgment is typically good for 8 years unless renewed. So a creditor or a debt collector could potentially renew a judgment shortly before the 8-year period is up. So even if somebody gets a judgment against them, maybe that person is judgment proof. Maybe they don't have the ability to pay, or they can't be they can't have their wages garnished now, but in the future that might be a possibility if either within 8 years they have collectible income, or if the judgment is renewed shortly before the 8-year period is up and another 8 years starts again. So there are certainly consequences for a judgment, even if at the time of the judgment the defendant is judgment proof.
Yeah, and I will say one of sort of the practical consequences or how this works is during that 8-year period, the creditor or whoever is holding that judgment can request financial disclosure through the court
Mhm.
process. And through that financial disclosure, they can, serve a set of questions on the person who the debt is or the judgment is against, asking them to disclose that financial information. So clients will often see that and then have to show once again, okay, my income is still exempt, or
Mhm.
show I'm not collectible, or potentially at that point things have changed.
Right.
There is a little bit of background noise. If people could mute, that'd be great. Thank you.
Yeah, so just going to common exemptions, there are a number of exemptions that we could cover, but these are by far the most common. So if somebody gets benefits from DCF or from the Vermont Department of Health Access, and that can include SNAP benefits, Reach Up, fuel assistance, Medicaid or Dr. Dinosaur, there are a number of as you see, a number of benefits, then all income from that person would be considered exempt, even if they have, income from employment that could still be covered by the exemption laws. And this again, a creditor or a debt collector can still file a lawsuit. They can still pursue a debt. They just can't garnish income from somebody who has an exempt income source. And more exemptions, Social Security income, veterans benefits, workers' comp, alimony, disability or retirement pension payments. Again, these are all sources of income that cannot be, directly garnished if somebody has a judgment against them. And just looking at assets, there's the homestead exemption, that's the common one, the limit of $125,000 in value. And we are looking for the homestead, we are looking at the equity that a specific person owns or has in the home. So, if that home is, let's just say, jointly owned with a sibling, maybe their equity is we're looking at their share, that specific person's share of equity. So it's the equity of that, you know, 1/2 ownership share. Um,
And just to add to that, it's also then the equity. So if I own a house with my sibling and I have a judgment against me and my share in the home is 50%, I can only claim 50% of the equity in the home, but I also only get 50% of the exemption in times. So it's sort of a little tricky when you're calculating that. And I will say, sort of in practice, again, how some of this works, when you're showing those exemptions, you can often just provide the other party or through financial disclosure, proof of Social Security benefits with the Social Security statement or proof of like food assistance, SNAP, by showing that statement. And so that's sort of generally how that will work in practice.
mhm. Thank you, Stacey. Okay, so this is just a way of showing, what somebody's equity might be. Maybe the value is 150,000, but then they have, subtract the mortgage, and you get the equity amount. So again, in this case, if the creditor was awarded judgment, they're not likely to foreclose on the lien because they would not, have anything from this exemption. Okay, so
So now we'll go into sort of post-judgment a little bit. And so again, sort of interest in Vermont is 12%. And that means that that's going to sort of accrue, 12% annually. And so oftentimes what will happen, especially in the line of work that we have with low income clients, is people will have a judgment against them and they'll think, okay, if I just make this small payment, I'm actually doing something that's helpful and I'm going to, pay on that judgment. And with the interest, that's not always true. So sometimes if somebody's making a small $15 a month payment, the amount that they're paying may not even be meeting the interest. And so the principal on that judgment is never going to get paid off. Sometimes if they're able to pay a little bit more, they will. And so sometimes if you're negotiating a settlement in a consumer case, it can be really important to see if you can get the other side to waive the interest, because that may be the only way the client's going to ever be able to pay off that judgment. Or, potentially we'll talk about bankruptcy. If somebody ends up with a large judgment against them that they're never going to be able to pay off, that may be a time where they want to consider something like filing a Chapter 7 to wipe out that judgment, especially if it looks like in the future, they're going to have increased income or they're looking to clear up their credit.
Right, right. The $15 a month may seem attractive to somebody who has, very low take-home pay, but in the long run, that might be pretty detrimental, just because it's a long-term payment plan.
And so then one of the other things that can happen is that at times creditors will say, okay, I'm not going to sue you to collect this debt. We're going to write it off. But we're going to also issue you a 1099. And so clients will get a 1099 form, which is sort of a discharge of debt form that will say, we're giving you a 1099. We've forgiven this amount of debt. And there are consequences to that with the IRS. So when you get a 1099, that forgiven debt is generally becomes taxable income to you in that year. And so a lot of times, if you have someone who's low income and now they've received a 1099, it's going to make it look to the IRS like you have a large amount of taxable debt and you might then not be able to pay the taxes. The way to deal with that is there's a specific form, I believe it's IRS Form 982, that you can file with your taxes to show the IRS that you're insolvent. And I believe when you go to that form on the IRS website, there is sort of a worksheet where you can calculate to determine, do you fit that definition of insolvency? And so if you're able to meet that definition of insolvency and you file that form, the IRS will then say, okay, you're insolvent. We're not going to count that as taxable income and we're not going to tax you on it. The other option too is if you file a bankruptcy, anything you discharge in bankruptcy is not taxable debt. So that's another way to sort of deal with it. And so that can also be a reason why, if you're getting a case dismissed in court and you can get it dismissed with prejudice, that's an adjudication of the facts. So then they can't issue you a 1099 and say, okay, we've forgiven that debt, because through that court process, you've established that there is no debt that can be collected on. So we'll
I'm
do a
going to go.
quick, oh, yeah, go ahead, Rachel.
I'm going to go over the small claims process. It's just again a very brief overview from both plaintiff side and defendant side, just to cover that. So small claims court, it's slightly different than superior court. It's a more simplified, streamlined process. An attorney is not required in this case, and typically these cases are quicker and just have fewer steps than superior court. For example, when somebody answers a complaint in small claims court, it's typically they're just checking off a box saying, I agree or I disagree to the claim. The plaintiff can only request money in small claims court rather than other forms of relief. And just overall, it's generally a more simplified process. So there instead of 21 days, there would be 30 days to answer. It's the amount of money requested would be up to 10,000 typically, but the limit would be 5,000 if it's a credit card debt or a medical debt. So again, typically smaller amounts than we would see in superior court. Now, if somebody is wanting to file a small claims case, again, they don't need an attorney to do this. There are those limits, of course, and they can only sue for money, but this might be an attractive option for somebody who maybe they don't have an attorney, or maybe they are just seeking an amount that's under the limit. They would have to fill out a small claims complaint form and serve it on the defendant. They'd have to describe why that specific amount of money is owed. And then they would have to pay a filing fee depending on the amount of debt or amount of money that they are claiming in the case. Now, if a lot of our clients are low income, if somebody would have trouble filling the filing fee or paying the filing fee, they can ask the court to waive the filing fee. And there is a request form for waiving the filing fee on the judiciary's website, as well as the other forms that a person would need to file a case in small claims court.
Yeah, and I'll just add that, like one of the biggest benefits to small claims, especially for pro se, either plaintiffs or defendants, are those relaxed rules, right? So the rules of evidence are a lot more relaxed. So it's a lot easier to sort of present a defense or present a case if you're pro se in small claims, which is why a lot of these sort of end up in small claims, unless they're suing you for a larger amount or want to go through the whole discovery process, which isn't available in small claims.
Right. And as well as answering just, saying I disagree or I agree versus going through, each individual claim and responding to that. Now for bankruptcy, I'm going to very, very briefly touch on bankruptcy. It's, there's a lot more to go into, but this is just a quick overview. Bankruptcy is often a solution if somebody maybe they have a very high amount of debt. They don't expect to take on much more debt in the near future, and they just need a fresh start, a clean slate. That especially, if a person has judgments against them, that bankruptcy can be a good solution just to help people start over. There are two types that we typically see. These are for consumer debtors. A Chapter 7, which is the liquidation bankruptcy, and then the Chapter 13, which is the reorganization bankruptcy. And for Chapter 7, it's again a more streamlined process. The debts are discharged, but if somebody has assets that are not covered by the bankruptcy exemption laws, those assets may be sold to cover the debts or lost by the debtor. So typically it's ideal in situations where somebody either has most or all assets that are covered by the exemption laws. Maybe they don't own a home. Maybe they don't have any assets that are that can be used in the case. Now, Chapter 13 is slightly different. This would be a 3 to 5 year payment plan. The payment plan has to be approved by the bankruptcy court, and the debtor would have to show that they have the ability to pay off this plan. For example, if they have a steady income, or they, for whatever reason, can demonstrate the ability to pay, they would have to do so in order to have that plan approved. But this would be more ideal in situations where maybe somebody owns a house that is not covered by the exemption laws, and they want to keep their home or their car. They might want to look into Chapter 13. I will also add that Chapter 7 has a means test. Most of our clients would qualify, but that again is checking to make sure the person has a low enough income that they can do a Chapter 7 bankruptcy.
Yeah, and I'll just add that, Chapter 7 is really meant for unsecured debts. And so the
Mhm.
reason why someone who's low income may choose to file a Chapter 13 if they have enough income is usually for reasons related to secure debts. So it could be, we have a mortgage on our home and we've fallen behind on the mortgage, but through the bankruptcy process over those 3 to 5 years, we can get caught up and potentially avoid foreclosure if you have enough debt. Vehicle loans can be a little bit tricky. In a Chapter 7, you're either going to have to reaffirm the debt, which means you agree to continue to be responsible for the debt after the bankruptcy is discharged and over, or you have to find a way to pay off sort of in full the value of the vehicle, because otherwise, because it's secured, you run into issues in a Chapter 7. In a
Mhm.
Chapter 13, again, you have that longer period of payment time. So the key with Chapter 13 is really, do you have enough money, and would that be beneficial to stretch out some of those payments over those times? Sometimes, the interest can be a lot lower in a bankruptcy, and so that gives people more flexibility in payment. So that's often why low income people are choosing between one or the other.
Right, right. And those exemption laws, there are a number of exemptions that can be applied. There are even wildcard exemptions that would cover, you know, general property or cover unused amounts of exemptions. So oftentimes, a person might think, oh, I'm going to lose my car, or I'm going to lose my, different assets, but maybe those assets are already covered anyway with the exemption laws. So, it depends on the person, but these are the factors that we might look at to determine the best chapter of bankruptcy to file under.
Yeah, and I'll just add, because I don't think we have a slide on the bankruptcy exemptions, but generally the bankruptcy exemptions, as long as you've lived in Vermont for the requisite amount of time, you can choose between the federal exemptions or the Vermont exemptions in Vermont. It sort of states each how every state has a law that determines which exemptions you get to use, and in Vermont you get to choose. And so the exemptions that we were talking about earlier when it came to debt collection can be the same set of exemptions you can choose if you choose to use the state exemptions in bankruptcy. So it's sort of that same homestead exemption of 125,000, the same bank exemptions. If you read through them, Vermont's are pretty entertaining because they were written so long ago. There's how many bees you can have, how many
Mhm.
oxen, things like that. But it's a long list of what you're able to keep protected in a Chapter 7 and in a
Mhm.
bankruptcy in general.
Yep, tools of the trade. That's
Yeah.
one. And then again, very, very basic overview, but certain types of debts can be discharged in a bankruptcy. Some debts can't. Most of the debts that we see could be discharged, like credit card debt, car repossession deficiencies left over after repossession, utility debt, medical debt, back rent. These are all ones that can potentially go through a bankruptcy. There are a few exceptions. For example, domestic or family obligations like child support payments, alimony payments, some tax debts, loans that are obtained through fraud or embezzlement, criminal fines or penalties, charges from DUI convictions. So there are a number of debts that just can't be discharged in a bankruptcy. But again, most of the ones that we see on a regular basis um, could potentially be discharged. There is a credit counseling course requirement. So shortly before filing and then after filing, there's another course, and this is required for everybody. There are a number of approved agencies that the person would take a course and then get a certificate. And this is generally informational. Um, it covers alternatives, debt management strategies, alternatives to bankruptcy, just to make sure the debtor, knows all of their options and has that information before filing bankruptcy. Um, and I want to say that is good for 180 days before filing. So once the filer or the debtor files bankruptcy, there is an automatic stay, and this is where the creditors are notified of the bankruptcy filing, and so the creditors would have to cease collection activity, and that includes lawsuits and other ways to collect a debt. So that could be another benefit for the debtor, that once the bankruptcy case is filed, collection activity ceases from those creditors that are notified. Um,
Yeah, I'll just add that it
mhm,
also will stop sort of other court actions. So if you're in the
mhm.
middle of a debt collection lawsuit, filing that automatic stay will put a halt on that case moving forward as well,
Yes.
which that can be a little bit complicated with divorce. So I'm not going to go into that because it's complicated, but I will say if you have a client who's in the middle of divorce, you really need to think out the timing of a bankruptcy because it can also temporarily stop a divorce. It can stop a foreclosure action, it can stop a
Mhm,
repossession action. With those, you just need to be careful that you're not just filing to stop, because if you're just filing to stop, that can be considered fraud, which can have its own set of consequences. But if you have a debtor who's really able to potentially get caught up and they're, in the middle of a foreclosure action or about to be repossessed, filing a bankruptcy quickly can be a way to sort of temporarily halt those and then resolve those actions and allow the client to keep those things if they can get through the bankruptcy process.
mhm. Right, exactly. So, um, and then bankruptcy will stay in a credit report for 10 years. And this, that this may be a deterrence for some folks, but it doesn't. Some people might think it prevents them from getting credit in the future, and that's not true in every case. It can be a detriment to obtaining a conventional mortgage in the future, but it doesn't necessarily prevent somebody from getting a loan or credit in the future outright. Um, and again, people are looking at benefits and consequences, and um, weighing these to see if bankruptcy is the best choice. Um,
Yeah, and I'll just add that, sort of it's hard to predict because clients will often ask sort of like, how is this going to affect my credit score? And sort
mhm,
of the formulation they use for a credit score, none of the companies are going to tell you what that is. But generally, usually before somebody's filing bankruptcy, they have a lot of negative credit. And so it's really a balance. Like before the bankruptcy, nobody may loan to you because you're on the hook for all these debts. And after the bankruptcy, it's showing up on your credit report that you filed bankruptcy, but now also you don't owe anyone any longer and you can't file bankruptcy for a number of years. So in
mhm,
some ways, it balances pretty evenly with, where are you sort of better off not filing before or after. Um, and it's really sort of a little bit tricky to figure out, but it can really give people that fresh start. And
mhm,
I've had clients where they'll immediately get credit card offers. And so the other things to tell clients to look out for is, really read the terms because
mhm.
you will get offers right away, but they'll be bad offers. And, there'll be really high interest rates and other situations where now, because you can't file bankruptcy again, you could very quickly end up caught in debts that you can't pay that now you're really stuck with. And so
Yes.
we often advise people to be really careful and sort of mindful of credit after bankruptcy.
Yes, or scams. There are a number of scams that can take place after, just preying on people's vulnerabilities and the knowledge that they, because they filed bankruptcy, they might be in a bad financial spot. And yes, I would add that for Chapter 7, at least, you can only file a Chapter 7 bankruptcy once every 8 years. So that's, again, it's timing it is pretty important because if you expect to take on much more debt in the near future, then you have to wait another 8 years before doing another Chapter 7, and that you know you want to time it in a way that maximizes the fresh start that you would get.
Yeah, and you can, I mean, I have seen people who file multiple times. I do think every additional time you file, you're going to get more scrutiny from the court, but it is
Hmm.
possible to do.
Yeah. Okay, so student loans in bankruptcy, this is a common question. Can you discharge student loans? It is possible. There are some extra steps to consider, unlike other debts like credit card debt or medical debt. Um, the the person would have to file a petition for an adversary proceeding or adversary pleading. They have to show undue hardship, and there's a three-pronged test that they would show present ability to pay, future ability to pay, and then good faith effort to repay. And this is showing that there is, an elevated hardship in this case. For example, if somebody has a disability that would prevent them from repaying, and they, don't suspect to have or don't expect to have a future ability to repay. Maybe they've made some attempts, or they've contacted the lender about a hardship plan. Um, but again, they have to show, some sort of undue hardship in order to potentially get the student loan discharged in bankruptcy. Now, for disabilities, there may be other options. There is, and I'm going to go over in the next slide. There's the Total and Permanent Disability Discharge Program for federal loans, where a person might be able to get the loans canceled through that program instead of going through bankruptcy. So while student loans can be discharged, maybe there are other options that are quicker or easier or just less expensive than going through bankruptcy just to discharge the student loans. But again, if a person has a private loan, maybe these federal loans or federal loan programs would not be helpful for those types of loans. Um,
Yeah, and I'll just quickly add, for a long time, the rules about discharging student loans in bankruptcy were
mhm,
really strict, and it really depended on how states interpreted them. So parts of the country, it would essentially be you could never discharge a student loan. Vermont was always a little bit more lenient, but it was still a really tough standard. And in the last couple of years, I can't remember the exact case, but it's relaxed a little bit and the rules
mhm,
have gotten a little bit more open so that it's no longer true that it's impossible or, people would sort of refer to it as being pretty much impossible to discharge.
mhm.
However, like Rachel said, if somebody has a disability, going through that process is definitely the easier path. But if that's not the case, or if somebody's filing a bankruptcy anyway, it's definitely something to talk to a private bankruptcy attorney about because there has been this recent change that's made it a little bit more permissible.
Yes, yes. And yeah, exactly like Stacy said, if they have other debts or other benefits of filing the bankruptcy, that is something to consider as well. Um, and these are just some programs that apply to federal loans. The most common that we see is the Total and Permanent Disability Program, and then the Income-Driven Repayment Plan. Um, there are other ones like closed school if the school closed before a person got a degree, um, you know, um, and another several other options that can be accessed. The Student Loan Bars Assistance website has a pretty good explanations of each program, so that's worth a look.
Yeah, and I'll add that oftentimes clients and, I think even a lot of us don't know. You usually end up with many student loans over the course of, graduate school, law school, and you don't know what's federal and what's private. And I believe within the student loan borrower assistance site, there is a link to another website where you can put in your information and it will help you determine what type of loans you have to be able to, know, okay, well, these fall under the federal, so I get these protections or remedies, whereas the private, there's a lot less. And also as a plug, if you're doing consumer work from a debtor side, the NCLC guides, the National, oh God, now I'm going to mess up with the
National Consumer
acronyms.
Law Center.
Yes, their guides, and they put out the Student Loan Borrower Assistance website. Their guides are great. They'll walk you through all the different processes and all the different like steps. And they have like pretty much a complete library for every consumer related topic where you can either get it virtually or the book. And we rely on those quite a bit. So if you're looking to do this work, I would definitely look at the NCLC website.
Yes, especially for the student loans because of all these recent updates in the last year or two. They, really are keeping track of all these the changes to the programs and publishing as they come along. So it's worth a check.
Yeah, and
Um,
Vermont also has one attorney, Josh Cohen, who is sort of like a national student loan expert, and he runs a website. I think it's something like Student Loan Lawyer.
yes.
If you just look up Josh Cohen, and he's another resource that we'll send clients to if they're trying to figure out what to do with their student loans. So.
hmm Yeah, I believe his consultations are $200, but he can be accessed through his website, and he will be able to give an individual consultation and look at somebody's situation for that.
Yeah, and he also periodically does more in-depth student loan trainings, which if you end
hmm
up doing that work, it's worth catching one of those.
Yes.
So I think that's pretty much brought us to the end, but we still have 5 minutes for questions. I'm assuming the chat works, but also feel free to just unmute yourself and
Mhm.
ask us a question. That's our contact information. If you have any follow-up questions, please let us know. Or if you want, if you give us your email address, we could probably also send out the PowerPoint if you want to see the slides.
Yes.
So we'll hang on for questions.
This is Dave Polo. Can you hear me?
Yep.
Yes.
Okay. So I just want to comment about the FDCPA, which is an incredibly powerful statute, I think, for debtors. And one thing that I find really amazing is if it is a third party that's collecting it, be it a law firm or a debt collector, merely sending a letter that they not contact your client anymore. And if they do, it's a per se violation of the FDCPA with statutory damages of $1,000 plus attorney's fees. That doesn't mean you necessarily get it, but merely because you have a license to practice law and you send such a letter, it could be a per se valuation. I've always gotten a kick out of that over the years. And most of the time, the debt collectors do honor that and that they won't send any letters. And it seems like all that violations that occurred maybe in the odds and in the 2010s don't seem to happen anymore for reasons that are unclear to me because I don't see them. But I still have folks that come in and I will send out that letter and the calls and harassment stops.
Yeah, I think you're right. I mean, I think we've also found that even though the FDCPA doesn't apply to those original creditors, sending original creditors a letter that also says, don't call me and sort of uses some of that language.
hmm
And we've sort of even included in ours, like, if you continue to call me, especially if I'm telling you I'm exempt, the only
Yeah.
purpose is harassment. And if you're just calling to harass me, now you're violating the Vermont consumer protection rules. That often sometimes will stop, if I'm telling you there's nothing you're going to get from me, please don't call me. We've had decent luck with that too, to get the
Yeah.
calls to stop.
Yeah. Even before there's a lawsuit filed, if somebody is
Yeah.
completely judgment proof, there's no harm in setting the statutes and showing that they, um, you know, just giving the heads up that they are judgment proof might be enough to, persuade a collector to stop contacting them.
I have a quick question. So I guess it's a follow-up on Dave Polo's comment. So if a client gets a lot of phone calls and you want to send a letter out, who do you send it to? I mean, you're just getting a phone call and you can't send a letter to a phone number. Do you send it to
Yeah.
the last known creditor and that's their obligation to track down who the successor debt collector may be?
Yeah, so that can be difficult, and that's I would say in many cases the collectors or the creditors that are calling on a regular basis are also sending letters. So oftentimes they would receive a letter saying that this is the debt, I'm the debt collector. Maybe it would include some language about the FDCPA, and then they would get a bunch of calls for the same exact debt. So if they don't, that can be tricky, but in many cases that I've seen, they're getting both letters and phone calls.
I've also advised people in the past, answer the phone one time and say, okay, I want to send you something, right? Like maybe it's going to be a payment, maybe it's not. Give me the mailing address of where I should send you something. And then, I mean, there's nothing that says you can't say I'm going to send you a payment and then not send it, and then you might get an address. I don't know how, I mean, I don't know how well that works, but you can try it, right? And then, you only have to answer it one time and talk to them and then not again.
Right. Yes, and they do have to identify themselves as well. So, the person should know who they're talking to.
I've found most of the time that the debt collectors will leave messages, and a lot of times a prospective client will have a phone number and a lot of times an account number, and that's enough once you call back to find out who that debtor is and send out a cease and desist letter.
Mm-hmm.
All right. Well, we're right about 11. We'll hang on for another minute or two, but thank you all for attending today.
Yes, thank you.
Thank you.
All right. Well, I guess we're good. I'll just stop recording unless anyone wants to chime in. All right. Thank you all again.
Bye-bye.
Bye.